Welcome to The Ethical Advocate for Accidents.
Welcome to the Ethical Advocate for Accidents with attorney James Sadigh. For more than 35 years, James has helped injured Californians navigate personal injury claims, insurance disputes, habitability issues, and wrongful termination matters, always with a focus on ethics and clear, honest communication. I'm Leanne Lyon, and today we're joined by criminal defense attorney Jasmin Haghani. Together, we are discussing what happens in California when a DUI accident becomes both a criminal case and a personal injury claim, and how these two processes can affect each other. Hello, James and Jasmine.
Hello, good to see you.
Hi.
Hi. So, in California, when a driver is arrested for a DUI and after causing an accident, what happens first on the criminal side, and how quickly does that process begin?
So, when a driver is involved in a DUI accident, first, obviously, the police will respond. They'll come out there and they'll administer a variety of tests to see whether or not this person was under the influence or not. Those tests include field sobriety tests, breath, preliminary alcohol screening tests. And they look for, slurred speech, bloodshot eyes, other signs that could, tell us whether or not somebody's under the influence. And they will arrest and impound the driver's vehicle. And in terms of, obviously the accident scene, I'll let James speak on that. But from, that get go of the collision, obviously the paramedics will respond, and even if the driver is injured himself, although it is now a criminal investigation, they will give him, hospital or aid or whatever it is that he would need before starting the criminal process.
From a personal injury perspective, James, does a DUI arrest automatically establish liability in a personal injury case, or is that a separate analysis?
It's a separate analysis. It doesn't necessarily mean that the party was at fault for the accident. Because what if the drunk driver was stopped at the red light and he was rear ended? So he has no fault in creating the accident. What if the other party had ran the stop sign and slammed into the side of his vehicle or a red line? So none of those would tarnish the claim that the drunk driver at the time would have against the party at fault. However, in certain circumstances, a very creative defense attorney may come and say that because this person was drunk and his reaction was slower than a normal driver at the time, he could have avoided the accident in certain circumstances and he didn't. So, therefore, he contributed to the accident. And or he didn't brace his body fast enough at the moment of the impact, so therefore his injuries are higher than it should be. So he may be 10%, 5%, 20%, however that he can push at fault, which would reduce uh, the compensation to him by that percentage. That's how it goes.
Interesting. So, Jasmine, how do plea negotiations in a DUI case work in California? And can the outcome of a plea impact the related injury claim?
So, plea negotiations usually are when if I have a client and, there were certain indications that he was under the influence, whether he was above a point oh 0.08 or more. And sometimes you don't have to be a point oh 0.08 or more. I mean, it's just you have alcohol in your system that caused you to drive under the influence. And whether it's a collision or, you're engaging in unsafe driving patterns, um, definitely contribute to how the case can come to resolve. I had a case just the other day where my client was driving in the freeway, and the police report said he was going 73. The supplement report said he was going 80. Certain tests and field sobriety tests and certain procedures that the police need to follow weren't followed. And so, there's a 15-minute waiting period between when the driver is supposed to take the chemical test, usually down at the station. That wasn't followed. And even though my client did have alcohol in his system, it was a point 11, which is over the legal limit, obviously, plus a little bit more. I was able to negotiate a plea deal for him and get him something called a wet reckless driving. And there's also a dry reckless reduction in the charge. But, wet reckless, it's in terms of like your record and insurance purposes, and fines and fees are much lower and less. And, although he had to do the DUI classes and terms and probationary time, it was still a pretty good plea negotiation for him, and he was really happy. In terms of it affecting a civil case, I would say the standard in criminal law is higher than it is in civil law. And so, we are faced with beyond a reasonable doubt. And so when that standard is higher and you're able to get somebody to plea or to take a negotiation deal, or you're found guilty by a jury, that in and of itself is a much higher standard that could be used civilly against, now you become a defendant in the civil case as well.
But that only, but sorry to interrupt, but that only comes in if the party, the drunk driver, for the lack of a better word, was at fault in the accident. If he was not at fault at the accident, no matter what happens in the criminal case, um, it's not going to affect his liability in the civil case. Because again, if he didn't cause the accident and the other person was negligent in causing the accident, uh, this person who is either convicted or plead into the criminal case has no bearing on the civil case.
Right. And I was thinking, if I guess my answer would kind of go towards, if the driver was drunk and caused the accident, then
Then, in that situation, it actually makes a very easy case for the plaintiff against him because now they don't have to go to the civil court and prove fault. The fact that he was at fault and he was drunk, it kind of helps the plaintiff to have the jury or the judge just rule against him for saying, you caused the accident. And in certain circumstances, also they may be able to ask for punitive damage on top of every other damage. In a regular accident case, the plaintiff is entitled not only to his out of pocket expenses and medical bills, but also pain and suffering. If the jury finds that the person at the time that he started driving was drunk, they may be able, under certain instruction, on top of all those previously mentioned damages, also put a certain amount for punishment of the person, which could be extra 10,000, 100,000, whatever it is that the jury comes up with to punish him.
Yeah, I think related, James, many people assume that if a criminal court orders restitution, that covers everything. So what's the difference between criminal restitution and a full civil damages claim?
Well, criminal restitution, I'm going to leave that to Jasmine to explain more, but that is something that the district attorney or the city attorney, depending on whether it's a misdemeanor or felony, uh, they will assess those damages to the defendant in a criminal case as part of the sentences. There is a case law in California that basically states that those restitution damages will not affect the damages that you can obtain in the civil case against the defendant. So, in other words, if district attorney says the defendant has to pay $3,000 for example, in restitution, When it comes to the civil case and I'm suing the defendant for my client's injuries and damages, the defendant cannot take credit for the $3,000 that he paid to the restitution, and still has to pay the entire damages in the civil case, which again, as I said, out of pocket expenses, medical bills, loss of earning, pain and suffering, all of those. And Jasmine, do you want to say anything about restitution? How is it calculated normally?
Sure. Yes. Yes, of course. Usually there's something called a restitution hearing, when there are damages involved, whether it's an injury, property damage. And, it's ordered by the court and it's enforced through probation. So, as long as you're on probation, you'd have to continue to pay off the restitution, however much they deem is appropriate. And once your probation is over, it will ultimately have to turn to a civil remedy. And so that would be um, the enforcement through a civil judgment after your probation ends, because so long as you're on probation, the court has jurisdiction over you and will make you pay whatever it was that was brought forward by the victim or victims. And that's pretty much the extent of restitution. But as James said, in a civil matter, it's deeper than it is, I'd say, when it's ordered through versus when it's ordered through the restitution hearing. And sometimes people don't, show up to the restitution hearings. Judges don't have the paperwork or the bills or the damages to be able to order restitution. So I think that's where civil claims come forward as well as it's a different remedy, but it's still ultimately going on the same thing, same incident.
So, Jasmine, are there situations where a criminal defense strategy, such as protecting a client's Fifth Amendment rights, can affect the timing of depositions or discovery in the injury case?
I would say yes, absolutely. Again, every person has a right, to the Fifth Amendment, which is against self-incrimination. And, many of the criminal cases that I handle or most criminal defense attorneys handle, depending on the circumstances, is the defendant, AKA the client, is he going to be speaking? Is he going to be testifying? And so, whatever's done in a courtroom proceeding under oath, it could be used against you. And so I would say that yes, the timing would come into play. Sometimes, judges can order a stay on either proceeding, usually not the criminal proceeding, because there's a lot of statutory rights and timings that we have to follow in criminal law. But yeah, they do come in play, not only just in DUIs, but restraining orders and other cases that kind of overlap with the civil world. So definitely.
That is one of the reasons that as a civil attorney, civil litigation attorney, whenever I have a client that may have been involved in a situation that there is a criminal proceeding alongside of it, I definitely reach out to a criminal defense attorney if he doesn't have one already. And if he has one, to the one that he already has, and coordinate with him or her how to do this. And if needs be, I will go into the civil court and file a protective order and ask the judge to stay the proceeding, as Jasmine said, pending the criminal outcome. Because in the civil proceeding, if they want to interview my client, which they have a right to, or take his deposition, or do any kind of a discovery, we don't want to answer those by saying I'm taking a Fifth Amendment right and not answer it, because later on that answer will be in front of the civil jury and they presume guilt psychologically. We just want to stay the proceeding. Nothing can be done on it until everything is done in criminal proceeding, and see what happens there. Because if it ends up being a misdemeanor conviction, that's much better than a felony conviction, because in a lot of situations we can keep the misdemeanor conviction out of the civil proceeding, and also nothing is said in a criminal proceeding that can come back and haunt him in a criminal or vice versa.
So, as we wrap up today's episode, when two attorneys are handling the criminal and civil sides of the same incident, how important is coordination between them to protect both the accused and the injured party's rights?
Well, in my opinion, as I was saying, it's very important. I don't want my civil litigation to be hurt by conviction on that side, or anything that may be told. But more importantly, I don't want anything that my client says in our case to be used against him in a criminal manner. Because after all, whether he is found guilty of a crime or not, whether he has committed the act or not, as his attorney, or her attorney, my duty is to make sure that he doesn't that he has all of the constitutional protection during the criminal proceeding, because after all, it's his life. He may end up spending time in prison. Civil case is only about money. Life and liberty is more important than money, in my opinion, and I think that's what it is. Jasmine, take from there.
Yeah, sure. And I'll touch on that a bit. I mean, the standard is different in a civil proceeding versus a criminal proceeding. So somebody may be found liable civilly because it is a preponderance of the evidence, which is it more likely than not that this occurred? I'm sorry. And in the criminal world, we have beyond a reasonable doubt. So, is there a reasonable doubt as to what occurred here? So it could even, have a negative effect almost, because if you're found liable in a civil case, but they don't find that standard in a criminal proceeding, then that could also affected, as well as there are situations where, DUIs or other criminal charges are actually resolved, and there are possibilities of a civil case coming. There's a statute of limitations. There could be, a victim doesn't know that they can go after the defendant, civilly. And so when even, when taking a plea, there's something called no contest, which is it's the same as saying guilty. But when you say no contest, it can't be used against you civilly, and it doesn't have the same effect as it does. I mean, it still means, you're guilty for the purposes of criminal court, but now that no contest plea can't be used against you in a civil situation.
Well, that's pretty fascinating. And that is it for today's episode of The Ethical Advocate for Accidents. Jasmine, thank you for being here. And if you'd like audience to know more about attorney James Sadigh and his work representing injured Californians, visit jamesadigh.com. If you found this discussion helpful, be sure to subscribe, share the episode, and leave a review so more people can better understand how these complex cases unfold. Thank you, Jasmine, and thank you, James.
Thank you.
It's a pleasure. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.